The broadcast is now starting. All attendees are in listen-only mode.
Hello and good afternoon, everybody. This is Bernard Wolfsdorf, your moderator today. We have our excellent panel of EB-5 specialists, and I hope to provide you with all the latest news in the EB-5 arena. Introducing our panel today, our first speaker will be Michael Gibson, one of our regulars of EB-5 Info. If you want to know all about the EB-5 arena, just go to EB-5 Info and you'll find his website very knowledgeable. Michael, thank you for joining us today. Secondly, we have Jor Law, our second participant, and congratulations to Mr. Jor Law, just got engaged. No longer have 3 complete bachelors on our panel. We have 2 more to go, but making progress in that arena. Am I off topic? Because I tend to go off topic from time to time. Something just pinged up. I'm not quite sure what that is. For those of you who are new to the program, please pardon my bad humor. The way to get through this program is to throw in bad jokes. No laughing is required. By the way, you can click onto your chat function. We will be answering all your questions today. The other big, huge development, at least for those of you who are California licensed attorneys, is we do have approved, that's not pending folks, but approved CLE credit, 1.5 hours. So not only are you going to learn everything about EB-5 hot topics and critical issues in the EB-5 arena, but you will also get free CLE credit. For those of you seeking CLE credit, you can email my associate, Robert Blanco, that's R. Blanco, B-L-A-N-C-O, at wolfsdorf.com, and he will send you a certificate of attendance. We are kind of fairly strict on this kind of stuff, so we do have your name if you are in fact logged on, and we will have to verify that. Of course, we're lawyers, we want to do things properly. So our second speaker, Jor Law, securities attorney and formerly engaged, Mr. Jor Law from Homeier Law. This is a firm of absolutely superb securities corporate lawyers. They are our go-to people. And there we have young Aaron Goforth. Aaron is the president of Wright Johnson Business Plans. These are our go-to folks when we need to count those jobs and put business plans together, not only in the EB-5 arena. Aaron is notoriously understated, but he's the guy who gets it done. I would speculate that Aaron and his company, Wright Johnson, has probably done more EB-5 business plans than anybody else in the industry. I have no proof of that, but they have done many, and have many regional center approvals. These are the guys I go to, and as you can see, Aaron also has a very pleasant smile and good front teeth. One of his many attributes, in addition to putting together, he's also a snowboarder. The company is headquartered in Colorado, and Aaron is, the company's headquartered in Florida, but Aaron actually works out of Colorado, I believe. So there you have it, our panelists today. I'm just killing a little bit of time to make sure that everybody gets online. Folks, we set a new record today. 522 people had registered for this program, over 500 people. So I'm going to have to set a new target of maybe 700 for the next one. I'm a little crazy like that, so please, if you find this interesting, share it with your friends. And my purpose, so you understand my purpose, I have an ulterior motive. My ulterior motive here is to simplify EB-5. Now, my panelist, Michael Gibson, is going to laugh at me and complicate it. my panelist Jor is going to scare the living daylights out of us with the securities panic, and so will Michael. Aaron and me are going to be the go-to guys and tell you that, sure, it's complicated, but it is possible to simplify some aspects of the EB-5 program. So let me share with you three thoughts, or one thought, three opinions. We're very active in the EB-5 arena. Our office filed almost 100 cases just last month. And we have a pretty clear understanding of what's going on in this arena as a result of this high volume of filings. And, you get these calls from prospective clients, from attorneys, and they want to do an EB-5 case. The EB-5 arena is one of the few areas where somebody who doesn't have a Nobel Prize or win the green card lottery can sponsor if they have $500,000 to invest in a project. So what are the three issues that are absolutely critical to get up to first base? Issue number one, choose a good project. Select a good project. What is a good project? Well, Michael and Jor and Aaron will help us answer that question today. What is a good project? And good comes in two sizes. Firstly, there is that question of immigration approval. Number one, is this project going to work in terms of getting your 526 approval? Number two, sometime down the road, be it 5 years, 6 years, 7 years, or 8 years, unless it is an equity investment, that investor is going to want their money back. And even if it is an equity investment, 8 to 10 years later, or sometime down the road, that person's going to say, okay, I got my green card, I'm an American citizen, I want their money back. And if they don't get that money back, they may not be happy. So the first question really is select a good project. The second question is select a good lawyer. Well, that's really easy. You could pick anybody on the panel who practices immigration law. I guess I'm the only one. Stop making silly jokes, Bernie. That's not even funny. Yeah, you need to have somebody who's experienced. They are certainly more experienced than me, but, stop the self-serving statements. Those aren't going to work. So, number one, you need to choose a good project, both from an immigration approvable perspective, and number two, from an investment perspective, and that's where the registered investment advisors come in, such as Michael Gibson, who is a FINRA registered broker-dealer, has all the permits, been around a long time, will kick the tires for you and help advise you in terms of selecting a good project. So that is absolutely the start. The second, again, choosing a good lawyer, very, very important. And, I turned 60 this year. What is the third, again, the third critical ingredient? Oh, ouch, my brain doesn't work. Senility has set in. How am I going to deal with this? I absolutely don't know what the third point is. But number one, choose a good project. Number two, choose a good lawyer. And number three, oh, ouch, is there a third one? I think we're stuck on two. So, sorry, a little bit of weak humor here today. We have only two critical ingredients right now for success. So, enough of Bernie Wolfsdorf. Let's switch over to Mr. Michael Gibson. Michael, I see you appropriately stole some slides from Suzanne Lazecki of Lucid Professional Services. I'm a friend of Suzanne's, so I have to give her a good plug, and so have you. Hey, this is an interesting slide. Michael, talk to me about this recently released data you are showing receipts of approximately 2,000 cases per quarter. In the fiscal quarter 1 of 2014, running from October to December, you showed 2,143 filings. That would tell me, since I can do some mathematics, if I take off my shoes, I can count past 10. If that quarter had 2,000 filings, one can anticipate that current filing rates are running at about 8,000 or 9,000 a year. Assuming 6,000 or 7,000 of those get approved, derivatives at least 2 for every petition and Chinese nationals, that would tell me that we've got usage running of at least 20,000 visas a year with a quota of 10,000. So gives us some idea of volume, but Michael, this is not my slide that I borrowed from Suzanne. This is your slide that you borrowed from Suzanne. So take it away, Michael. What do you see on this wonderful picture that we managed to decipher from your Apple and put it in Word, which wasn't so easy? What do you see here? What does this tell you, Michael?
Yeah, thanks very much, Bernie, and I appreciate being on the call again. Hopefully we'll have another great year of education for the people out there. There's a few things to note, and yes, I do have to second thank you very much to Suzanne, who let us borrow her data. Well, the data is from USCIS, but she compiled it in a very nice graph. And for those who are not familiar with Suzanne, I recommend getting onto her blog right away, subscribing. Lucid EB-5 blog, it's one of the most well-known in the program, so she does a great job with updates on the industry. So here's a couple things. You touched on receipts. The volume of receipts really did jump up in quarter 1. What we're probably going to see, if we don't cap this year, certainly next year we'll cap, but as people have noticed before, when they try to do the math, should receipts equal approvals plus denials? No, that's not the way. Normally, there's, as everybody in the program will know, there's a backlog, and so the receipts will probably not be adjudicated for, as we understand, maybe between 10 months to a year, perhaps more than a year. So you're correct. The volume has increased substantially. What does that mean? The EB-5 program is very popular. A lot of people are filing I-526s. We all know that, and that's great news. I think what I would like to focus on here is the approval and the denial rates. And what, both for the 526 and the 829. When I look at the 526 and just looking at it visually, I am, if maybe shocked is not too strong a word, at how low the amount of denials that there are versus the approvals. And I think that's the first thing that draws to my attention, how very many, first of all, total adjudications they've been doing, which if you look at 2013, quarter 1, quarter 2, just look at the total number of both approvals and denials, and you have less than 1,000 or just at 1,000. You get into the third quarter, fourth quarter, and you can see substantial increases in the amount of cases that they're adjudicating. So that's very welcome news to everybody in the program. I think another thing that's very welcome is that the denial rate is very low, and well, it was until the first quarter of 2014, and we'll see the second quarter coming up how that fared. But certainly the good news is that the volume that they are processing has increased. I'm not going to say substantially, but it's a trend upward. So that's something that we all welcome. And until the first quarter of 2014, the denial rate had been very low, and all of a sudden we seem to get a spike in there. And I think there's two schools of thought regarding both the 526s and the 829s. We see the same thing. For the 829s, second quarter 2013, no denials. 421 approvals, no denials. and I'll touch base very quickly on my thoughts why that is. Very few in the third quarter of 2013, and again, none in the fourth quarter. So you're looking at a period through 2013 where you had 26 denials and hundreds and hundreds of approvals. So that's fantastic news on the 829. What I take away from that is that there's actually two schools of thoughts regarding the approvals and denials. And one is that, and this is the optimistic view, you want to look at the glass half full. It looks to us like the adjudication standards and policies and procedures have become more standardized and more consistent. So one would think that the training and the policies that have been implemented during both the Mayorkas administration and the new one have led to more consistency and better review, so the efficiency is increased, and the policies and procedures, the standards have been highly consistent. So that's led to higher approvals and higher adjudications.
Michael, let me jump in very briefly and interrupt slightly. You correctly point out that in the first quarter of 2014, October through December 2013, 811,526 denials, clearly double that of the prior quarter. So that's quite a statistic. Number one. Number two, if you're a practitioner and you have just one denial, that is an awful day, and that is the sort of scary message. There was talk that, and then of course if you get an 829 denial, that person's going into removal, and that is triple ugly. And the bottom line is one has to be extremely careful. However, I want to throw some different statistics out at you, Michael. I was recently in China, part of a roadshow on a new project, and the agent that I was working with had compiled some data which was very positive. And I want to throw that data out and see what its impact is. This is data through the end of fiscal 2013, and the statistic that was thrown at us for fiscal 2013 is an 82.5% approval rate. That is an 82.5% approval rate on a 526. If we take O1s, L1s, H1s, and other things that we do, 82% approval rate is pretty acceptable. In the EB-5 arena, of course, that is a little bit scary because it's a 17.5% rejection rate. But what we see from the first quarter of 2014 is that those numbers are no longer valid, number one, and number two, there are cases sitting in the system from 2010. Now, hold your horses, folks. That's 4 years. Those old pending cases, are they going to get approved or are they going to get denied? And why aren't they sitting out there for 4 years? The answer, in my opinion, is that a fair number of them have problems and a fair number of them are going to get rejected. One other statistic from my little dog and pony show that I did in China, which was very interesting, is that 829s for fiscal 2013 had a 95% approval rate. Folks, 95% approval rate, 5% denial rate. And at the end of the day, the Chinese agents were saying, and very respectable in my opinion, Chinese agents, these are licensed migration agents, were saying, hey, look, here's a program with a 95% approval rate on 829s and an 82.5% approval rate on a 526. Is that a reasonable framework? And again, that's fiscal 2013. As Michael says, the statistics will change in 2014 second quarter. Michael, knock me down. What do you think about my comment that we have 82.5% approval rate for fiscal 2013 and 95% approval rate for 829s for the end of fiscal 2013. You think that's too positive? Is this a program we can live with those kind of numbers?
Yeah, on the 526, that's right in line with the historical average going back to the data that we have from 2005, I believe it is. So 80% plus or minus is about where we have consistently seen, some years higher, some years lower. So on the 526, I think we're in line. We're fine. And the 829s, I'm going to touch on that point that you brought up about the 95%. And here is the other school of thought for those in the pessimistic camp, if you will. And this is something that's circulated freely in all of the conferences that we go to. And there's a school of thought out there that says that, and I'm going to call this the Gitmo policy or Guantanamo Bay. And the strategy here is, if you're cynical, is that what happened is, as you have correctly pointed out, there are cases that go back years and years, even before 2010, that they have not been able to adjudicate for whatever reason. And the cynical view is that during the transition, when the guys at Laguna Niguel knew they were going to be out of the game, they, like Gitmo, they more or less transferred the hardest cases to Washington to be adjudicated. So my sense is, with a new training staff and a new staff, new administration, they did not want to come out of the gate trying to deal with a handful of very tough cases, which are probably going to get denied. Rather, they're going to approve all of the easy ones that meet all the standards. And then what we may see as the training and the staff improve and the procedures and policy, as that improves, they're going to start probably tackling these harder cases. And at that point, I think you're going to see that 95% rate come down. Now, whether it comes down a few points or substantially is going to depend on how they process. But there is a large school of thought out there that there is quite a large backlog of very hard cases which are probably going to get denied, and that's going to reduce the success rate for 829s probably, again, to about the 80% level.
And by the way, remember, if you've got a bad 526 and you've got a monster RFE you can't respond to, it's often best to just withdraw the case, and that doesn't even come up in the denial. So we're not counting withdrawn cases that get refiled. So the 526 problem arena is probably bigger. Let's not spend any more time. I think it's important to understand what is the fundamental here. Am I dealing with a program where there's a 50-50? There's a lot of negative in the program. Bottom line is, you've got about an 80% approval rate on the 526. You've got about a 90% approval rate on an 829. I submit those are good approval statistics, and this is a viable program. Michael, of course, being more cautious, is reminding us that those statistics are actually dropping, and that it's a lot tougher out there. Michael, let's move on to probable outcomes and do some analysis from the perspective of not only the 526 approval, but also the issue of getting your money back. And, I'm going to criticize you, Michael, and I'm expecting you to do the same of me, but your analysis here talks about full principal return. I mean, at the end of the day, I think some of my clients would not kill me, or at least not sue me, if they only get 80%. I mean, I want them all to get 100%. But the reality is, this is a business, this is a risk. Some of them may not get 100% back. What about an analysis if they were getting 70 or 80% back? Michael, just making trouble. Please take it away.
No, you're absolutely right, Bernie. I think it depends on the client, and we have a number of clients who said to us, and again, most of the engagements that we get come from immigration attorneys, and the attorney will tell us very clearly the return of capital is not the principal consideration. They would like to get it back, but if they didn't, and the green card costs $500,000, so be it. But what we did here with this chart was, what we tried to do is determine what are the probable outcomes, and this is a mathematical exercise. It's maybe not real world, but again, I want to thank Jen Galperin, who helped us set CFA from MIT. And what we did is we're looking at the the two principal questions that normally are directed at us. What are the probabilities that we get the unconditional green card, that is the 829 approval? And then secondly, what are the chances that we will get a return of capital? And so to answer your point, 80% on the 526, maybe 80 to 90% on the 829, those are good odds. What we're looking at here with this chart is the probability for, and we can't look at EB-5 for this, the data set is too small, so we look at all startups going back, I think we went back to about 1972, startups in all different industries and asset classes, and we came up with these numbers, and basically what we're trying to point out here is simply the mathematical probability of each event occurring. And as we know in EB-5, there's only 4 possible outcomes. Whether your client's going to be happy with the first one, maybe not so happy with the other 3. We just wanted to illustrate mathematically what the probabilities are of achieving both the first and the other 3.
Michael, let me jump in here. You know, I mentioned I was in China a week or 2 ago on a dog and pony show. And the project actually was a 4 Seasons project. What I'm finding in the industry is that there are a lot of major players coming into this industry. The developer in that case was Silverstein that did World Trade Center. They're doing a 4 Seasons in New York. You know, this to me, and again, I'm not plugging the project, I'm just saying it seems to me that with a lot of major institutional entities, developers, Silverstein, other big companies like that getting into the game, that we have a better product, and that perhaps some of the, if you evaluate based on all businesses, well, that's one thing. But right now, the market does seem to have a few quality players coming in, and of course, there's a lot of junk out there. What's your comment on that, Michael?
Yeah, no, without any question, the EB-5 program as a form of capital raising has definitely become more mainstream. And to that end, we have seen Fortune 100, Fortune 500 companies coming in and using it as part of their capital stack. So that's great news. But this is my point for the immigration attorneys who are online. Simply because there is a large developer in the offering, really does not absolve you of having to do the required due diligence because, and you brought it up, the World Trade Center, for instance, well, they're having trouble leasing floor space. So, you know, if the development into which the EB-5 investor goes into turns out to be a failure, regardless of whether the developer is a well-known entity or not, and trust me, they go out of business. You know, when I was at Citi, we saw a lot. We had a huge New York City portfolio. We ended up owning because all of the developers that we lent to, which were all the #1 guys in town, defaulted. So you have to still do the due diligence because the question also becomes what position is the EB-5 investor in, and typically they're subordinate. Usually, you know, you're seeing the bank loan get paid off first. You may see the GPs get paid off. The last guy in line to get a handout is the foreign national, and for the immigration attorney who put their client into that project, if for some reason they don't either get the 829 and or the principal back, there may be some questions, hard questions that they may have to answer.
Michael, I want to stop you right there, and I want to repeat what you said, because you talk highly technical, and many of us lawyers are really not nearly as sophisticated. Where is the investor in the capital stack? And I'm just taking this particular project because it's on my mind. What was so smart about the developer in this particular case is they basically put the investor first, ahead of the bank. And that is rare. Usually the bank is going to get paid back first. Whatever's left will go to the investor. In this particular instance, the investor gets paid out first, and the collateral that they're doing on this particular project is in fact the hotel. There's a hotel and a condominium, and the bottom line is that there's number one, extensive collateral, and number two, the investor is first in line. Michael, talk to us a little bit about this type of analysis. Most immigration lawyers, unfortunately, do liberal arts degrees. Fortunately or unfortunately, we're trained to think, but we're not very comfortable or knowledgeable in this area of capital stack. Can you simplify this for us? Where is the investor? I mean, the bottom line is we know if we buy a house, we have a mortgage, the bank gets paid first. If we go bankrupt or taxes first, bank second, and other creditors third in line. Is this the number one analysis from your perspective, Michael? Where are you in the capital stack?
It's definitely a significant factor. The problem is it's like everything in the EB-5 program. It involves a series of trade-offs. For the developer, they would love nothing more to get 100% EB-5 funding, typically, because one, it's very long-term, it's patient, they're limited partners. It's not like a bank who's calling you every 2 to 3 months asking you how you're doing with your CO and where's their money. The EB-5 is a great source of capital. It's low cost, and there usually are very, very few restrictions as to how you can use it, unlike other forms of private equity or debt. And so the developer would love nothing more than to get, say, the whole funding through EB-5, and we do see that quite often. However, the problem with that, and this is something that the economists will tell you, is that if you try to build a project, even one, a full-service, say a hotel or assisted living or other asset, which does have a heavy job creation component, it's typically hard to justify all of the jobs that are needed or required to produce in order to justify the full EB-5 component. So typically what the developers are doing, and also, by the way, as you mentioned, China. In China, they don't want to be the only game in town. They don't want to be the only guys at the table. That, to them, that looks very suspicious. Where if it's such a good project, why don't you have bank finance? That's a good question. So the developer is oftentimes going to get a mix, and what the analyst needs to focus on is what component of that mix is debt versus equity. If it's all debt, in the case of an EB-5 loan, what position am I in and what are the repayment schedules? The big problem, and we'll talk about here in a minute, is regarding the escrow, and if, at what point does the EB-5 money need to come in to fulfill the bank obligations? Is there bridge financing? So there's a number of issues that if it were up to the developers, they would love to take the EB-5, but typically the project will not qualify for purposes of job creation requirements if that's the case. And once you start introducing other third parties who are contributing equity or debt, you have to be very careful to know what position your clients are in.
Michael, let me make this simple from my point of view. I know that there are one or two folks who are out there raising 100% EB-5 money on their projects. I think they're wasting their time in China. The Chinese market is much more sophisticated. They're not going to go for 100% capital raise. If the developer doesn't have skin in the game, I think they're wasting their time and they're going to fall flat. I think there's tons of product out there right now. People have the opportunity to choose, and developers who are in this game had better put some of their own money in as well. Otherwise, they're going to find they're not in a good position with regard to selling. Michael, let me flip over. Do you want to comment on these slides? I'm kind of flipping them through only because we have a lot of them.
Yeah, I think we're good. Yeah, Bernie, I think we're good here.
So wishful and probable outcomes, we've done that one. Let's move on to the next one. Michael, you've covered some of these points. I'll give you the opportunity to comment further.
Very, very briefly, you're right. We did, for the audience who was here last year, we talked about these are the two risks that our clients are concerned with. One, they won't get the green card. Two, they won't get their principal. And these are the reasons why. They're very, very simple. Why the conditions will not be removed. Capital's not invested according to the business plan. We used to see that a lot. Nowadays, as the program has matured and as everybody has been getting all the RFEs, I think a lot of that has been corrected. We don't see that material change as frequently. And I think USCIS has relaxed a little bit as well, their position. I think you can have some minor changes, and they will approve those. So that's been not a big problem. Investment not at risk, that's almost never the issue, but we'll see one example shortly. And then the sufficient jobs were not created, and that's the real big one. And you touched on it. The problem is with the projects with 100% EB-5 finance, the job creation numbers are so high that this is where we're going to probably see challenges. When you see 100-room hotels creating 4,000 jobs, I think at that point you start to question what are the inputs and outputs. So those are on the 829, and the Y principle will not be returned, and typically it's just the value of the investments insufficient to pay all the investors. And again, as I oftentimes see, typically the EB-5 investors are at the back of the line, so they have to wait until everybody else is fed until they can get their return.
So the bottom line is it was a bad business, didn't make enough money, and they're not going to get their money back. Michael, you've touched on one of the themes that we're going to focus on when we're talking about hot topics here today. Aaron's going to go into this. There is a bubble out there, and a bubble that may well burst now that I'm using analogies. There are some 6,529s that need to be filed soon. As a result of the surge in this program, from having maybe 1,000 cases a year, suddenly 3,000, 4,000, and Judgment Day is coming. The 829 filings are coming up. This program has really only surged in the last 3 or 4 years. And it's only now that these 829s are coming due. And at that point, the 829s have to be filed, they're going to have to be approved, and we're going to have to show that the jobs are being created. This is going to be Judgment Day for a lot of regional centers, for a lot of projects, because if the data's not there, many of these cases were based on business plans and projections. 829 is a realistic framework. Was that money spent? Do you have the receipts? Prove to me the money was spent. Do we actually have to count the jobs and show the jobs were sent? Maybe not. But we certainly have to show the money was spent. We need the receipts. And we find that some regional centers, quite frankly, don't have their act together. Now, when I started, I was making fun of myself. There were 3 critical ingredients. Ingredient number 1 is choose a good project. And I repeated that several times. Ingredient number 2 is choose a capable lawyer. I think it's important to have someone guide you through the process, but that's a self-serving statement. And the third point, oh gosh, did I forget it again? Nope, I got it. Don't worry. My technician here is getting worried that I may forget. It's the question of source of funds. There are only 2 issues here, folks. The stuff is simple. Well, not really. Number 1, choose a good project. Number 2, show the money was lawfully earned and you had an appropriate source of funds and path of funds. That's the other big issue. Number 1, the project is good. Number 2, the source of funds. So you mix these 2. It's like putting 2 ingredients in a frying pan. Number 1, choose a project. Number 2, choose a source of funds. What is a 526? 526 parts. Number 1, the project. Show the jobs are going to be created. Number 2, show the money is being cleanly earned and legit. And it is the investor, him or herself, who puts that money at risk. The investor must put the money at risk. You put that in the frying pan, you switch on the stove, and you get a 526 approval after you've had an RFE. Those are the 2 ingredients. This stuff is not rocket science, folks. That's what you need to do. Prove the jobs were created. Prove the money was lawfully earned, and you get yourself a green card. Michael, I'm interrupting as normal. Let's please continue with your slide and do the analysis here. Why many investors will lose some of their investment. Explain to me why, sir.
Yeah, again, this is the slide we used last year. The principal reasons that we see is really a lack of transparency. There's other issues involved, but typically it's a lack of disclosure. And This is really where I caution the immigration attorneys who are on the line to be careful. You have to be careful that you understand first what is given to you, and then you also understand what is not being told to you. So what we've seen in the past is that with the promotion of the project, there's a lot of marketing that goes along, which is fine. But they may obviously, when you're marketing a product, they want to tell you the highlights. They don't maybe want to fill you in on a lot of the risk involved, or some of what we call omission. And Jor will talk about omission, but many times in the project marketing and promotion, the downsides are not explained to your client, and we oftentimes think that it's better to explain all of both the upside and the downside, what we call the strengths and weaknesses, to the client so that they understand what they're getting involved with before they make the investment, rather than, say, down the road 2 or 3 years or 4, they find out that there was a major material fact that had that been told to them, they would not have invested. And if they do lose their money, as is in the case of several of the EB-5 projects that we're seeing now that have lost their value and have gone bankrupt or are just, sitting idle, the investors are asking, why was I not told X, Y, Z? And, the question is going to come back to the immigration attorney. You presented the marketing material, that's great, but what about the possible downsides? And I think that's the one reason that we would recommend, again, doing more of an in-depth due diligence before you present these projects to your clients, just to give them as broad a picture of both the positives as well as the negatives. And then once they get that whole picture, then they can make a better assessment of if this is the right investment for them or not.
Michael, jumping in here, okay, for those who are real rookies, the document is the PPM, the Private Placement Memorandum. Marketing materials, folks, I don't even read them. I mean, that's the sales pitch stuff. That's the advertisement. Dump it. You've got to read the PPM. And hopefully the PPM is, and it could be a couple hundred pages. And you've got to look at the risk factors. If you want to be in this arena, folks, you go to PPM. You've got to understand, and that's, Jor's area of expertise, is the information in the PPM. If it's not in the PPM, that person's going to have liability. And Jor's going to fill us in on that. Let's go through, I know, Michael, I'm doing an article right now on Chinese retrogression, and the question is, well, what if it takes 6 years for an investor to get a green card? When is the money going to get released? Developers need that money released. That's a big issue. The question of what's going on with escrow, you don't even need escrow. After the first 526 is approved, after the first 3 526 is approved, that's what we're seeing in escrow right now. Creative escrows, a certain percentage or a certain percentage being held back. Michael, talk to me about this new topic of escrow. Do we put the money straight into the project? The money is spent, the project fails, the 526 is denied, there's no money to be returned. This is a big deal, and you folks need to be familiar with it. Where are we going with escrow, Michael?
Sure. This is the one topic that we spend the most amount of time on with our clients, far more than capital stack or even the asset class or the location or the principal's background. Really almost any other metric we spend on escrow, because unfortunately what has happened is that, unlike a few years ago where the 526s were being adjudicated in a few months, now we're all very familiar with a period of, well, it used to be over a year. The good news is that seems to be coming down, but even so, 10 months, let's assume 10 months, it's still far too long for the developer to wait for the principal to be released without being able to develop. And the reason is because if a developer has obtained bank financing, typically the bank terms are going to state that the development must begin within a period of time, usually 30, 60, no more than 90 days, for them to be able to use that facility. And so they cannot hold the equity into this escrow for 10 months and expect that the bank loan still remains there. So the developers are caught in a very difficult situation. They want the equity, they want access to the capital so they can begin the project, because bank financing may be involved. There may be some permitting issues. If they don't begin developing after a year, they lose their permits. And so it's a very, very difficult position for the developers. And what has happened is that a lot of the projects that we see coming online now, very, very few, less than 10%, actually use full escrow. The majority are using either no escrow at all or a partial, which is conditional on some trigger event. And it could be the round of funding that they've put into some account. It could be the approval of a 924 or 526. It could be some trigger, but the point is, the question is, again, for the immigration attorney, the question is really what happens. There's two things that are going to happen. One, well, three. The 526 gets approved, that's great. No, there's no issue. Then you're happy, everybody's happy. The two problems are going to be, one, either your client's 526 is denied for some reason, or the entire project is denied. It's just given annoyed. In the first case, it's usually not a huge problem if it's just your client, because most of these conditional or partial escrows have a reserve account, which accounts for 10 or 20% or some number of the pool, which they can repay to 526s, which have been denied for a source of funds or other issue, and that's fine. The big question, the big problem, and this is what we've seen, is where the entire project is given annoyed. And in that case, you're really in a big problem if there was no escrow
Annoyed is a notice of intention to deny for those who are not immigration gurus. We have attorneys, but we have developers and everything else. So if there's a project annoyed, Michael, please continue your questions.
Sure. So if the problem is if the entire project is denied, then what happens? And assuming, again, there was no escrow or even a partial escrow, let's assume 20% in reserve, well, you've got 80% of the population which is going to be asking for their money back so they can refile, and it's going to be very difficult. Now, here's where you need to be, you need to look at the asset in question and the development and the timeline. So what we do is we're going to look and see, is this asset relatively small in scale? Is this something that could be built within that 10-month time frame? Because and CO, not just built, but we want to see it operating. Because if it can be, then the lack of escrow may not be as substantial a problem, and the reason is because if the money was released and the development began, and let's say the asset was completed in 6 to 7 months, 8 months, and all of a sudden you get a project denial, well, at that point, typically it's not a problem because the developer will then go and either get bridge funding till the permanent kicks in, or go back to the original bank and say, look, the asset's complete. We want a loan on the entire, and we're going to use the equity already built. They'll take the equity that has been created to use as collateral and repay the investors. So depending on the size of the asset that's in question, the lack of escrow may not be a substantial problem, but you need to be very careful to ensure that if the development is not complete, there are forms to repay the investors.
Got it. Michael, 2 points. Point A, having approval of a 924 as a condition, approval of the 924, that's the regional center. I think what you mean is approval of the 526. One of the caution, of course, is you cannot have the 829 as any form of condition because that would be, of course, a guarantee on return. Jor, just looking at the time here, I think it's time to cross over to you, Jor. Jor, what are you seeing on your PPMs? What are you seeing in the escrow arena, and what are you advising? Hello, Jor?
Yep, sorry, I'm trying to unmute here.
Yeah, I grabbed you kind of suddenly. I'm just looking at the clock, and I'm fast forwarding through some of Michael's stuff because of time considerations. We have two other speakers. Michael Gibson, thank you very much for your insightful comments. We're now moving over to Mr. Jor Law. We were on the topic of escrow. Jor, you got a typo there. It's June space 12. Sorry, he's such a perfectionist, and I'm such a pain in the ass. Oops, no bad language. Jor is a proper lawyer, so he puts in disclaimers here. Everything we say is not legal advice. Don't sue us. Hey, by the way, before Jor, Michael, something you forgot to mention, because I didn't give you a chance to it, was your new website. What is that website again, Michael?
Yeah, sure. EB5projects.com, and we have a special. There's a fee to register, but for all of your listeners, anybody who emails us, because as a courtesy, what we'll do is we'll give them free access to evaluate it. So basically, it's a portal. What we're trying to do is just encourage investors to reach out to regional centers and developers directly without the use of a middleman or an agent or a finder. We want to increase transparency in the program by allowing developers to put in as much information about a project and reach a community of immigration attorneys who have clients. They just don't want to pay the huge subscription or admin fees. So this is a form of direct investing in projects with full transparency. And again, I'd like to give everybody who listens in, anybody who sends us an email, we'll give them free access to evaluate it.
So just because, you know, this is a free program, I don't get paid, he doesn't get paid. This is Michael's new project, EB5projects.com, knowledge-based investing database. Should be some good information. I haven't checked it out, but you're going to be at the AILA conference next week. You've offered to give me a demo. I'm going to come and bother you. When is your little show, big show at the AILA conference, Michael? Where and when?
Well, we're having a booth, so we'll be there 24/7. You know, we'll be manning the desk, so anybody who wants to come by and tell me you're a friend of Bernie's, you get the special discount.
Whoa!
There you go.
Oh, great, lucky. That's the code. The promo code is friend of Bernie, and I know that I'm going to be there in Boston as well for the AILA conference. Wright Johnson will have a booth, so you can find out more and go and talk to these folks and kick the tires. And I was trying to jump over to Jor, but I caught him while he was eating a sandwich. So instead of listening, so we've got to jump over to Mr. Jor Law there, securities lawyer par excellence and recently engaged. So there he is, Mr. Jor Law. And I was going to try and get you to start on disclosure.
Yeah, you know, I'm going to go through quickly, you know, most of our slides. The message is simple, and in your own spare time, you guys could take a quick look at the PowerPoint slides. Ultimately, at the end of the day, you know, there's a big focus and push on broker-dealer registration and disclosure these days, but we can't forget what the SEC usually enforces against and what they've always been enforcing against and what they've already enforced against in EB-5 or other securities offerings, and that's the idea of disclosure, the idea that a reasonable investor is entitled to receive all material information that they would think was important in making an investment decision. So some of the key things we've talked about already, retrogression, Bernie talked about that a little bit. Michael Gibson spent some time on the escrow or lack thereof. And the offering costs are something, you know, I'll touch upon in the next few slides. But basically, the rule is that anything that you would think is important, or a reasonable person would think that is important in making an investment decision, that information all needs to be disclosed. Now, there is no magic, you know, black and white. You know, we always get calls from people or questions from people that says, well, do I need to disclose that? Do I need to disclose that? And many times the question is, we're not sure. Maybe That's ultimately a question that a jury decides, or a judge, or a trier of fact decides. But in many cases, if you have to ask, it probably is material enough that you have to ask.
So, Mike,
for example,
or Jor, just to be rude and interrupt, retrogression, and the correct word, by the way, is visa backlogs or visa wait line. Retrogression is the symptom, in my opinion, once you filed an adjustment and the numbers then go back. But that's the word that's floating around now. The question is Chinese visa wait line, Chinese quota. And I'm the one who's been writing articles about this and publishing and talking to the government about it since I serve on the EB-5 committee, ELA EB-5 committee. And at the IIUSA conference, we made this big announcement that we were anticipating a backlog coming up probably May, June 2015. We probably come up with a 2-year backlog. Now, it's really interesting because just last week, I was speaking to Charlie, updating it. Charlie Oppenheim, Director of Visa Control for the State Department, and of course, the government is backing off already. Why? Well, there's too many variables. What are the variables? Rate of adjudication, number one. How many cases are in fact? We don't know these things. We do about 9,000 cases in the pipeline. So my question, Michael, Jor, is how do we retrogression? The reality is Bernie Wolfsdorf is saying May, June, there will be a 2-year wait line. But now the government's saying, well, we don't really know, and it depends on the rate of approval. So maybe it's going to be a 3-year wait line, or maybe it's going to be a 4-year line. How do you disclose this? Do you say maybe there's an issue? The government doesn't know. I've been living and breathing this issue for weeks, maybe months, and I don't know. But I do know this. A 19 or 20-year-old Chinese kid could face an age out. And now I'm suddenly shocked to find maybe an 18-year-old kid or a 17-year-old kid may face an age out. So is it enough if I tell a client, hey, look, there's a bunch of cases in the pipeline. The government's probably going to improve the number of applications. There's a chance of an age out. And as long as I warn them that there's a chance of an age out, I'm covered. Is that the story? Or do I tell them this case could take 2 years, 3 years, or 4 years? I really don't know. Is that the sort of thing that's got to be in the PPM when nobody really knows? Jor, that's a ridiculous question I just asked you, but have a shot at it anyway.
Yeah, no one's ever really going to be able to put into words every single risk, even if they knew of it. But in reality, we don't know what every risk is. We always think we've got everything down to the last staple and the last paperclip, but there's the idiot factor. Some idiotic act, by just having chance of life, will happen and things will change, and that's okay. There are standard disclosures that unfortunately we just put in because we live in a litigious society. There's standard disclosures that we put in that say, well, there are things that we don't foresee that could happen that are risks. But to the extent that you have an idea of the risk, the more information you can disclose, generally the better. It's up to each kind of company and their attorneys to determine how in-depth they want to go in there, and there's no magic answer. There's no one that the SEC does not come out and say, well, if you disclose this and provide a timeline, that you've met your duty. But if you didn't do that, you didn't meet your duty. So you're going to see in the marketplace varying forms of disclosure, different levels of detail and information and descriptions of risk differently. And it could very well be that all of them are insufficient, and it just as well could be that all of them are sufficient. In reality, of course, most of them are going to be sufficient if someone's taking the time to do that. The real test is at the time that a judge or jury or any trier of fact is analyzing this, would they feel that that risk was appropriately communicated? So
Jor, No, I think you got it right there. Jor, let me throw something out. You and I did a panel recently down in Orange, kind of fun, but I was blown away by a statement you made, which is, you put these PPMs together for a living, private placement memorandum, and I know you do a good job. You're a smart guy. But then you spoke about sort of PPM that some of the big securities firms put together. And it was clear that those were two different documents, that some of these big firms put so much more into these documents. And then you were talking about you have a EB-5 compliant PPM, you have a what I call big securities firm type PPM. My clients always like, when's the PPM coming out? They take weeks and months to put together these massive documents. Who's right in this area, Jor? You, who may put together. What's the answer here? Where should we be going?
I think that if people do these properly, the average cost of offering documents would trend up toward the average cost of offering documents in non-EB-5 industries. So, EB-5 existed and was popular, companies have been raising money and doing PPMs for the longest time. And the legal price point and the amount of work that goes into those PPMs, hasn't really changed. And it's in general higher than the legal price point and amount of work that's put into EB-5 PPMs for two reasons primarily. One is folks that are looking for EB-5 capital for some reason or another seem to always be unwilling to pay professional fees. The second is that the market is resistant to a number of securities best practices that in the non-EB-5 world, no one blinks twice at. Private equity funds that raise money or companies that go out and raise private placements with attorneys in non-EB-5, when they're told by securities attorneys, you should do this, 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 and this, they usually say, okay, and they do it. In EB-5, we consistently get pushback from almost every party involved in EB-5. Why do I have to do this? Why do I have to do that? Why do I need this license? We get questions that are very similar to, oh, so it's illegal to murder someone. Well, how do I get around that? And that's something that's been pretty unique to EB-5. And for that reason, I think a lot of the paperwork that hits the market is not as in great condition as in the non-EB-5. And that's not to necessarily say it's the lawyer's fault or even the company's fault. It's I think it's what has happened is the companies, for better or worse, have made a business decision on the amount of disclosure they wish to give and the amount of risk that they are willing to take. Yeah, and as securities attorneys or as any attorneys, when you represent the clients, you cannot, short of doing something illegal, you can't, like not listen to your client. So the professionals are bound in to some extent by what their clients allow them to do.
Sure, we've seen that in the last 2 or 3 years, but as I mentioned earlier, there are a lot of major players getting in, institutional developers who understand how important it is to do a proper PPM. There are, what I'm going to say, securities lawyers out there swimming through, looking for cases with 829 denials coming up and inadequately prepared cases. I think there's going to be a lot of people who really wish they had spent the money doing a proper PPM. I think there's a sea change. The SEC's been out there, people. I think we're going to see a major change in the industry after a few people have been sued, after a few people find their houses gone, that maybe they should comply. And I think this is the next area where focus on the fact that those PPMs had better be done properly. They had better full disclosure and provide all necessary material information and risk potential investor if they want to survive and not find themselves sleeping here in Santa Monica on the street where we have a fair number of homeless kids. Let's talk a little bit about broker-dealers.
Yeah. So broker-dealers, this next slide has, a list taken directly from the SEC website. And essentially, if you say yes to any of these questions, you're a broker. You're not a finder. You're a broker. In the eyes of the SEC, there are, people that would argue with the SEC stance. For example, I disagree with their stance on the second question, but you don't generally argue with the government and win. So, the conservative thing would be to read these types of questions, and if you answer yes to any of them, the question is, well, am I a finder? No, you're not. You're a broker. And if you're a broker, you need to be licensed to conduct brokering activities.
I think this is so important for our attorneys to note that they need FINRA registration in order to be a broker-dealer. Sorry, Jor.
Right. And you did get a question that was sent to you ahead of the call that said, well, if I'm a 1099 and I'm just working for someone on their staff, what licenses do I need? And the answer is you still need all the broker licenses that you would have had because, you probably answer yes to three out of four, maybe all four of these questions.
And George, just help me again. Maybe Michael can jump in. What license is that again? Series 22, 63, 7. What number are we talking about here?
It really varies based on the type of transactions you want to be able to do. The traditional securities license that most people have gotten in the past, the stockbroker's license, for example, is a Series 7. There may be other exams that you might be able to take, for example, like a Series 79 or a Series 82. And bear in mind, unless you set up your own broker-dealer, you can't just go and start getting paid for this. You have to take that license and hang it under someone else's license. And what I've found recently, because everyone keeps asking me, why do I need this? How do I need this? And what I've found that works really well in explaining broker-dealer licensing requirements and why it's there is by giving an analogy. Most of us on this call know that you don't practice law without a license. We know that you don't practice accounting without a license. And one area that's very, very similar to broker registration is real estate broker registration. And many people in EB-5 understand how real estate licenses work. And the idea is, and no one questions this, but the idea is that if I'm going to make a commission affecting a real estate transaction, I need a license. And usually people don't question that. What a lot of people don't know, unless they are real estate licensees, is that if you're a real estate licensee, you can't pay a commission to someone else who is not a real estate licensee. And it makes sense. The government just wants to make sure that real estate transactions are done by people that know how to do them, that are operating ethically and to certain standards. And it's the same thing with securities. It's just a different type of asset that the government wants to regulate. People are putting hard-earned money into investment and possibly could lose them. And therefore, they require a securities license. And if you're a securities licensee, it's not so easy to get around it by saying, okay, well, I'll just work with a securities licensee and they'll pay us. No, they're supposed to pay someone else who's a securities licensee. And if you think about, so every time you start thinking about, do I need a license? Is this securities? Like, why is it fair that the government is doing this? Just think about how the question might, just rephrase and re-ask that question to yourself. Would I need this license if this was a real estate transaction? And if the answer is yes, it's almost always a yes that you'll need it for securities as well.
So, George, just watching my time because we're running a little low on time. Jobs Act, didn't this throw it out the window?
No, Jobs Act is something different. Traditionally when you sell securities, when you go and raise capital, you have to register your securities. Most people don't register securities because it's costly and takes a long time. So they find exemptions. In EB-5, there have been two exemptions that have been commonly relied upon. One is a Reg S exemption that allows you to raise money pretty much however you want, so long as it's offshore and to non-U.S. persons. There's a few issues to that. One is you can't market to people in the U.S. You can't market to U.S. persons. You can't sell to U.S. persons. You can't even have a website in the U.S. that's accessible by people in the U.S. without password protecting it. The second big issue is that that's only a federal exemption. When issuers raise money, they have to comply with state and federal laws. So the Reg S does nothing for state exemptions, and it may be that there is no state exemption that wouldn't work if you did only Reg S. So a lot of people also, or alternatively, rely on Reg D. And Reg D essentially is as well, if you don't do a public offering, you pretty much only take accredited investors, we're going to more or less leave you alone. And the problem with Reg D, of course, is you can't publicly solicit. You can't advertise. You shouldn't be going to trade shows and having booths. You shouldn't be going to EB-5 investor seminars and telling everyone you have a project. You shouldn't be, you know, having a website that's not password protected. You shouldn't be going to an ALA conference, buying a sponsorship booth and handing out offering materials. That's all general solicitation. It used to be illegal. As of late last year, September 23rd, 2013, you could do that. You could generally solicit. You could take advertisements out on the radio, newspapers, billboard ads, ads on the side of buses, and you could still call it a private placement on one key condition. The biggest, I mean, several key conditions, but the biggest condition is that you can advertise to anyone and their mothers and their dogs and everyone in the world that you want. However, the people that actually invest, they have to be accredited investors, and they have to be verified as accredited investors. They can't just sign a subscription agreement that says, yes, I have high income, I'm accredited. You actually have to take further what they call reasonable steps to verify that they are accredited investors. You know, since Bernie's going to make me plug myself anyway, I did launch a website called verifiable.com.
Give me the chance to plug you. Let me plug you first, Jor. I was just going to get into that plug for you. Hey, I don't pay these guys to put them online, so I give them plugs. But before we get into this term accredited investor, I have a little question.
Hello?
Can you hear me now? Am I clear?
Sorry, I heard some tones. What was the question?
I think we're clear. There was a little bit of a buzz. My techie is busy playing with the numbers.
Testing. 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 Bernie, did I lose you?
I'm still here as well, Jor. I don't know if we lost Bernie.
Do you hear the tones?
Yes.
Okay.
By the way, I'll plug you before Bernie gets back on. So I said it last year, the best site to come to EB-5 in a long, long time, verifiinvestor.com. Fantastic. We're going to implement it in our portal. And I encourage everybody, all the regional centers out there who are doing it on their own, to just outsource it to Jor's, because it's a lot better, it's a lot more efficient, and it's a lot more secure.
Yeah, I mean, verifiinvestor.com was something that, you know, people came to our law firm to discuss, and frankly, it's not worth paying a law firm to do this, and many law firms won't do it. But it's important feature. You know, I went out to, you know, investigate what the other competitors were doing. Some of them were not legally compliant. A lot of them were taking your investors' information and doing something else with it. So I needed to come up with a solution that I felt, you know, that I could refer to my own clients and use myself as an investor. And a lot of law firms and people that have wanted to do things correctly have been now using it.
We love it. I encourage everybody to go there and use it. If you're a regional center, just integrate it. It's easy, it's elegant, and it's simple, and it's effective.
Very good.
Is Bernie back on? Oh, good. Bernie's back on.
Yeah, I had a little technical thing there. It's something to do with an on-off switch. I guess off means off. I'm now back on. Very advanced technical skills I have. So, I'm getting good feedback on this, Joel. Well done. obviously you'll be ready to retire in a year or two with that very smart idea. But I have a question for you. I had this recently, somebody gave the opinion, a lot of the actual petitioners would be minor kids. Dad gives kid $500,000, and the kid actually files a petition. Question, somebody gave me the viewpoint that until that kid, because that kid doesn't have the money, until that kid has been gifted the money, they cannot be an accredited investor, because at the end of the day, it's the kid that's the investor. So
True.
Is it your position, Jor, that dad's got to give the $1 million to the kid before that kid can make a $500,000 investment in order to be an accredited investor? Is that a yes or no, sir?
Yes.
Wow. Okay. So you absolutely agree with that position. That's pretty complicated. Dad's got to give the kid $1 million when the kid's only going to invest $500,000. Otherwise, the kid cannot qualify as an accredited investor. Ouch. That one hurts. Okay. So we're going to try and get...
That's right. But, kid could always give dad back money, months later.
Yeah, but there could be gift tax consequences, et cetera, et cetera, et cetera. Mr. Tech, my thing's not advancing. What am I doing wrong here? Need to move the slides. Bio, what did you do? Bio, we know that Jor's Columbia University, top 2.5%. He's obviously smart. Let's move on to the next one. There's his contact information, Jor at HomeierLaw.com. Jor, thank you so much for always being so knowledgeable. We're going to go to our third speaker, Wright Johnson. My friend Kevin Wright decided to get on a plane today, so we have his better half, Aaron Goforth, president of Wright Johnson. Aaron, I hope you're there. The number one issue, folks, in EB-5 is job creation. I spoke about source of funds. I spoke about 3 requirements, a good project. Good project means job creation. That is why we've had 3 people so far. We've had Michael Gibson. He helps with due diligence. We've had Jor, the securities and corporate lawyer, who puts together the documents that we need in order to comply. And then we have the third of the stool. That word always sounds bad. The third leg of a 3-legged stool. Wright Johnson, that does the business plans, that helps us with the magical word that immigration is absolutely obsessed with. And by the way, guys, we put these things back on YouTube, so be careful what we say. Verifiable detail. There we have it. Job creation through verifiable detail. Aaron, if you're there, talk to me about verifiable detail. What exactly does this mean? What does the government want? Are they handing out microscopes to go with this? Are these micron microscopes, regular microscopes, or the kind of Clarence Darrow Inspector Clouseau microscope that I have here in my drawer when I have to review I-9s and my eyesight's going? What does this mean, verifiable detail, Aaron?
Yeah, Bernie, so thanks for the question.
Oh, you sound like Darth Vader. Is that Darth Vader? Are you in a dark room there? A little bit louder. I think the voice thing is only half fixed, but we'll take it anyway. This is Aaron Goforth, also known as Darth Vader. Aaron?
All right, excellent. Thanks, Bernie. I have a little bit of a head cold, so bear with me. So verifiable detail is important really at 2 periods of time as it relates to proving jobs. So the verifiable detail at the 526 stage in the economic analysis needs to be well supported, and USCIS is scrutinizing this data for good reasons. Because verifiable detail is not only important to USCIS, but will be ultimately important to the investors as well. So first, let's look at the inputs that go into job creation. So typically for a real estate project, it would be construction and some type of operations of the facility. typically third-party support of these key business assumptions is critical. So for construction, you may be looking at a bid from a general contractor showing that these numbers are reasonable. For operational revenues, if it's a hospitality project, for example, you may be looking at HBS, PKF, or other third-party market studies that demonstrate that the revenue projections are in line with industry standards and regional to that market.
Okay. I think the sentence you just made is the absolute gist of the entire EB-5 program. This is about job creation, and there's two things now, economic inputs that are being looked at. Number one is construction costs, and number two costs, and when you feed data into your econometric plan and projection, that's what it's all about. Take it away, keep going, Aaron.
Yeah, no, and USCIS is scrutinizing this data because it's critical to the investors, because not only does USCIS need to accept their 526 petition, but when they're looking to make their residency permanent, they need to provide evidence that the project met the metrics that were used for the input to the model. So if they said that hard costs were going to be $10 million for the development of the hotel property and operational revenues were going to be $2.5 million, they're going to need to demonstrate at the time of the 829 filing that those metrics were hit, and jobs should be recalculated based on what money was actually spent and what revenues were actually hit by that specific project.
Excellent. Thank you so much. I hinted at this point earlier about the 829 bubble. People have been talking about the China bubble bursting for the last 20 years. Yep, they went down from 12% to 7%. If that is a bubble bursting, then, I guess America needs that kind of bubble. But let's move into this 829. This is the removal of conditional stage, the judgment day, the 829 bubble stage. Aaron, you guys have done hundreds of business plans, dozens of regional centers. Talk to me about your concerns in this area. At the end of the day, we file the 829, remove the condition, get the full green card, but we have to verify that the jobs were created, and you see a potential problem in this arena. Talk to me about it, Aaron.
Yeah, well, I'll start with our friends at IIUSA shared with me that only 20 regional centers have successfully adjudicated 829 petitions. And as the program has become more popular, clearly, based on the statistics shared earlier and the issue around retrogression and the number of petitions at the 526 stage, the next logical step is these folks are going to process their 829 petition. And it's really just a forewarning that you want to make sure that everybody that's involved in the process is able to provide the required documentation that's going to be needed for the individual 829 filing. So as we were just discussing around construction and operational revenues, you need to make sure that all the stakeholders engaged in the process are documenting the appropriate information that's relative to the information that was used at the 526 input stage. So what that means is, going back to the hospitality example, if you declared that you were going to have $10 million in hard costs, at the 829 stage is when we need to demonstrate what was actually spent on the development of the hotel asset. And you don't want to go back to the general contractor or the developer and ask for these receipts 2.5 years later. You want to make sure that everybody's aligned on the front end, what needs to be executed and documented, make sure that people have a positive outcome.
So we have about 500 regional centers. We have 20 with some track record and experience. Let me take my shoes off so I can count how many do not have experience and who are not listening to this webinar and are not collecting this document and may well be homeless outside my office in Santa Monica a few years from now after they get sued because they cannot provide the documents necessary to meet the 829 and the 829 gets denied. You have to make sure that you are tracking the input metrics and that you have audited financials, corporate tax returns, and the appropriate documentation to show those jobs were created. So, Aaron, thank you for that. I'm going to pull you in on a few of this. This is that picture of me from my youth. somebody said to me, Bernie, is that your bar mitzvah picture? And the answer is, no, it's not quite my bar mitzvah picture, but it is a pretty old picture because the beard's gone gray, the hair is going gray, and it's not because of EB-5, but let's see if we can hit hot topics. This is our firm, Wolfsdorf Rosenthal. Come and visit us in Santa Monica. This says that I fly without wings. It's not true, but some of it is relatively true. There's my contact information, bernard@wolfsdorf.com. Google my name. You'll get me. You got a question? I expect to hear from you. So hotel guest expenditure. Aaron, I have a question for you. This information that I got was from the last USCIS teleconference, and we were blown away. They were talking about, oh, wow, and by the way, a good portion of the projects nowadays are hotel projects, and they were saying you can count guest expenditure in these three circumstances, which was really amazing, and we were all shocked and totally blown away by this wonderful, wonderful determination. And here's what I found. People were not interested in following up with this wonderful analysis because despite these three circumstances, people felt safer creating job inputs from construction expenditure than from hotel guest expenditure. What's your take on this, Aaron? Are you using hotel guest expenditure in your job projections, or are you still just relying on construction and operational costs?
Yeah, so the guest expenditure issue has historically been very tenuous with USCIS. And our position has been a bit conservative, that if a client has a legitimate argument of why they're bringing new demand into the marketplace that wouldn't be there otherwise, and are willing to take on the necessary market studies and provide the quantitative data that USCIS wants to see, we're happy to support that effort. And we have seen a couple guest expenditures be approved over the course of the last 6 months.
But that's only where you have
for these folks, because what USCIS historically has wanted to see is that indeed this hotel is bringing a population or a group of people into the community that wouldn't be here otherwise. So we're not talking about the third Holiday Inn in a metropolitan area. We're looking at hotel assets that are very unique, maybe bringing in visitors that wouldn't come otherwise. So maybe it's the first 5-star hotel. There's demand for those services in the market, and it's been underserved. A designate or a resort-based asset may also qualify for guest expenditures if it's, again, bringing people into the community. They're going to be spending money in the community that wouldn't otherwise be there if it wasn't for this asset.
Yeah, it makes total sense. These are the three exceptions. Unmet demand. You need to have high hotel occupancy rates. Without high hotel occupancy rates, you can't argue unmet demand. The second option, you serving a special segment such as long-term guests, and the third one, you're building a hotel because there's a sports arena. But I was still surprised to find that a lot of hotel developers are uncomfortable relying on this because, not so easy and just a whole lot easier to keep the percentage of your raise down. You want to raise 100 million, just use 25 million for EB-5, 50 million for EB-5, get the balance from traditional sources, and don't extrapolate too much in regard to job creation through unmet aggregate demand and these three exceptions that were mentioned. I think we've kind of touched on 829 job creation evidence in your plan, in your summary, so I'll skip this particular slide. Job creation, let's skip that one too. Tenant occupancy, not too many people have won with tenant occupancy. Don't count the tenant jobs is basically what I'm going to say. That's a loser right now. Processing times. Hey, folks, some positive news. The government told us they're going to work on pulling the processing times down. They have done so. 12.4 months is pretty much the current adjudication time on 526. Whole lot faster on some projects that have prior approvals. 829s, 8.7 months. This 0.7 stuff, I think it's a little deceptive. I don't want to use the word deceptive. It's misleading to some people. That's worse. The idea that, at 8.8 months you're actually going to get a decision is kind of silly. But that's an average that we'll live with. And wow, look at this one, 924s at 4.4. Aaron, I understand that you got an approval for a regional center for the entire state of Michigan in 77 days. How do you plead? Guilty or not?
Not guilty. It was 73 days.
73 days, damn it. You beat me by 4 days in your assessment. 73 days to get the entire state of Michigan. But you know what? That's worth bragging about, except for one thing. Michigan really needs that help. And I understand that the government is very, very supportive. Good luck with that project. There's a big secret project he's doing. It's not secret anymore because I just told a couple hundred people. But simple bottom line is, look at the new website, the Immigrant Investor Processing Office, IIPO, processing times, improving dramatically, training a lot of people. I think these folks are doing a good job, a sincerely good job, and this is definitely good news. I think I'm happy to say we're going to see processing times come down to 8 to 10 months. That's my own personal prediction. Here's the whole story. I've spoken about this, guesstimates concerning the Chinese EB-5 issue. Here's the facts. Anticipated 2-year waiting line popping up May, June, July next year. Will it be 2 years or could it be longer? I think it could be longer. Based on the rate of approval, the number of cases in the pipeline, I'm anticipating it'll go up to 3 years and maybe 4 years. But that's total guesswork. Will Congress, in fact, fix the problem? No. Congress will not fix the problem, in my opinion. Everybody's talking about all these bills. We get this hype. This new bill got improved. This one, blah, blah, blah. I don't even want to talk about these bills because Congress, Eric Cantor just got beaten yesterday. Eric Cantor was no friend of immigration, but the Tea Party folks seem to be flexing successfully. I do not see the Republican Party leading us. I hope I'm wrong, but for whatever reason, Eric Cantor's defeat is definitely bad news for us. And we need the House, we need the votes. So I do not see them increasing the number of visas for rich people. Okay? That's my call. Do I see them extending the program? Yes, I do. I think the program will be extended. It would be absolutely disastrous not to extend the program. But simple bottom line is that I don't think the votes are there to increase the number of visas that are available. And we're going to have a Chinese waiting to develop sometime next year, 2 years, 3 years. If I was Chinese, and I am kind of Chinese, my wife is Chinese, my kids are Amerasian, speak fluent Mandarin, very proud of that, but they're Americans, of course. And if I was Chinese born, I would absolutely file my case yesterday to get my place in the waiting line, because that waiting line is going to get long. It's going to go up to 2 or 3 years. Could I have an age-out problem? Absolutely, you could have an age-out problem. If you're 20 years old and you're filing now, you may well have an age-out problem. If you're 19 and you're filing now, you may well have an age-out problem. If you're 18 and you're filing now, you might have an age-out problem. Why would you potentially have an age-out problem? Well, if it takes 2 years to adjudicate, if there's a 2-year waiting line and it takes 1 year to adjudicate, you're 1 short. Let me take off my shoes again and do some math. It takes 2 years to adjudicate. I get credit for the 1 year the case was pending. I'm 20 years old. At the time the case is approved, I'm over 21 when I deduct the time the petition was pending. So if I am over 21 at the time the petition is approved, after doing this calculation of deducting the time the petition was pending, I can still age out. I know this is how many times you do it. So those guys have been sitting and waiting for 4 years. Hey, here's the good news. You get to deduct all that time the petition was pending. It's an age-out bonanza, a silver lining for those poor people who've been waiting for years and years. I just hope those people who've been waiting for years and years actually end up with approvals and not denials, because then they're going to have a big, big problem. So those are some of the predictions. I'm just summarizing it. There is a second stage with regard to Child Status Protection Act. By the way, the Supreme Court just ruled on the CISPA case yesterday. No protection for the sibling category, the fourth preference kids that aged out. I surprised the Supreme Court went the wrong way, in my opinion, 5-4 negative. But that's a different issue. Doesn't actually impact us. They said that CISPA is only for protecting closer relatives and not siblings, and they left the sibling kids to age out and could not retain the priority date of the initial petition. This CISPA stuff is complicated, folks. I had a couple comments from last time that I should spend some more time talking about CISPA, but I want to answer your questions today so I can release my panelists and let them all go home. Spread the word about this. I hope that this has been interesting. With 9,000 cases in the system, even a 19-year-old could face a possible age out. I'm actually going to predict that possibly even an 18-year-old could face an age out. So these are certainly issues that need to be dealt with. Remember, the second stage of CISPA is you have to seek to acquire. That means you've got to file a DS-260 within 1 year of the visa becoming available and pay the fee bill, or file an adjustment if the person is in the United States, a 485, in order to lock in the child's date, and then the child's date is permanently frozen. You get a green card for somebody who's 25 years old if they were in fact locked in under CISPA procedures. So let's switch over to questions right now and see if we have any questions for our audience. Thank you so much for sticking with us. We had 500 people register. Whoa, we got a lot of questions here. Have you been following the SEC rulemaking and the revision of Form D? The SEC semi-annual regulatory agenda is on display now and to be published tomorrow. That was from Mr. Joe Whalen. Jor, this is yours. Have you seen any news with regard to SEC rulemaking and revision of Form D? Any changes that will affect broker-dealers? Jor, are you there? If you're not there, Michael, comment on this, please.
Yeah, this is Jor. We've been following it. Like the Form D, the changes and the timing of Form D, depending on different types of the different types of offerings. It's going to change it. It's going to be annoying, I think, for the EB-5 industry more than other industries. In general, I don't think it's going to have a large material effect. Any of the Form D, filing requirements. It'll just be a different type of nuisance in general, but in reality, the practical effect, of any Form D specific changes is not likely to be, so huge, I think. But we'll see when the changes become finalized.
Thanks, Jor. The second question is one that I normally avoid, but I'm going to new thing is like no question shall be too scary to address. What are the estimated costs for a new project to set up a regional center or partner with an EB-5 regional center? Well, those are two very different things. Getting a regional center approval today, I can just tell you it's the cost has dropped substantially. If we're talking about a hypothetical based on a hypothetical project, I don't know, probably you need to email me offline. on that rather than quote fees. I just want to tell you that the cost has dropped dramatically. You can get an approval now in 4 or 5 months. Here's an important question. Does it make sense to take your project to an experienced regional center? Now, I'm going to give a plug for another regional center that I work with because I did a lot of work with them on the SLS project, which is the American Dream Fund folks. You know, when you partner with an experienced regional center, you get more than just the ability to count indirect jobs, which is the whole thing with regional center program. You get advice with regard to marketing, you get distribution network, you get management, you know, small thing. You get an approval. Oh, we need the client's social security number. Well, why do you need the client's social security number? Well, because you've got to issue a K-1. Why do you need a K-1? Well, you're going to need that K-1 when it comes to filing the 829. So allying with an experienced regional center makes total sense, not just because it's cheaper or not cheaper to set up your own regional center, but because you get the experience of people who know what they're doing when it comes to running a regional center. But the cost of setting up a regional center has become quite reasonable. Email me offline and I'll give you some estimates of what it is. How does the new Supreme Court decision, oh yeah, that decision, thank you, and that's an attorney who I know pretty well, doesn't impact us. Basically, the decision of the Supreme Court, and the truth is I haven't read it, really impacts fourth preference, family immigration, the remote wait line. It does not impact us directly, other than if the kid aged out, could they in fact carry the priority date of the principal investor? And it looks like the Supreme Court is saying no. So let me translate that into English. Kid ages out because petition, the Chinese wait line turned into a 3-year wait line, got approved very quickly in 6 months. Kid turned 21 at the time of approval, wasn't able to freeze the age by filing a DS 260 or packet 3 as we call it, pay the fee bill. So now, can that kid carry the priority date of their parent when applying to adjust as a derivative second preference through the parent's green card? And the answer is no. They can't. So, yeah, maybe it does impact in some thing, but the bottom line is you couldn't do it before, you can't do it now, and you won't be able to do it tomorrow. The kids are going to age out. No relief for the kids. The answer is put another $500,000 in for that kid. Is there anything that I must do to verify? Okay, so there you are. There's an attorney I know. No, we've got your number. Just email us, and you get your 1.5. You had to stay on from 12:30 to 2 in order to get your CLE credit. Please, I'm not going to ask you to stay till the end. I'm not going to give out that silly code at the end that you can report, but we'll issue you some kind of certificate. Here's a comment from an attorney. It just says, nice. Is that a nice day, or are you referring to Aaron Goforth's good looks? Probably the latter. Can LLC investing in a job-creating enterprise be based in another country? No. Unless you call Puerto Rico another country, they do, but it counts, so Puerto Rico will work, but the answer is no. We want the U.S. jobs. Is it possible to get a copy of these materials? Oh, yes. You're going to get a copy of these materials whether you like it or not, but you could press delete, and then you don't have the problem. I'm new at EB-5 practice. Could I get a copy? Yes. All going to get a copy. And go, by the way, all our prior webinars are online. You can reach them too. What are the 526 and 829? Ouch. Sorry, folks, this one was quite advanced. We've been doing some entry level. The 526 is the initial petition that you file, and the 829 is the petition to remove the conditional nature of the green card. So if this was a marriage case, it's the initial I-130 petition would be the 526 equivalent, and the 751 petition would be the 829 equivalent if you practice in family law. Can you provide an overview of the total attorney fees and expenses the client incurs in obtaining EB-5? Yeah, I probably could, but you've left, so I will avoid the question. If you want to email me offline, I'll give you some idea of what the fees are. All I can say about my fees is they're definitely much too low. What documents should I prepare for the direct EB-5 for a restaurant? Well, people have been on the line for an hour and a half, and I don't want to keep them for the rest of the day. Basically, direct EB-5, you still need your business plan. If you have evidence of the jobs, I-9s, register for E-Verify, make sure these folks are legal. Make sure that you've got your $1 million. Make sure you can show the legitimate source of funds, path of funds. What documents? That's a repetition of the question. Who can help prepare a business plan? Well, there you have it. That was Aaron Goforth, Wright Johnson, and a PPM. That would be none other than Jor Law. What document should I prepare? Excuse me. For the director, some of this is repetition, so you can help prepare the bit. So that would be Jor. Hire a good immigration lawyer. We have a team. How do you get information that the percentage of principal returned or not returned? You don't. You have to calculate in advance. That's like saying, how do I know this is going to be a good marriage? You have to try and evaluate it before. That's where Michael Gibson comes in. Yes, very good question here. There's a comment. Immigration attorneys should not be putting investors into any projects. This is not the immigration attorney's job. Thank you for making that comment. I know you've left, but it definitely has to be repeated. Volume was fading in and out. Sorry, we have to fix that. Can you define regional center? Ouch. How can I define regional center? Regional center is an approval of a geographical area in relation to a specific type of project, which actually allows you to count indirect jobs. That's what regional centers are all about. It's in a process. Go look at the Form 924. Just Google Form 924, and these folks are having a problem with the sound. I hope my sound is good. Also, what about licensing of migration agents? Let me explain this. Migration agents are, I'm referring to Chinese migration agents. They are the licensed agents. We, the American attorneys, are not licensed agents in China. They are the licensed agents able to, in fact, gosh, I hope the sound thing has been fixed because there seem to be some issues. Will the slide be available to us? Yes. Please give Jor's email. I'll do that at the end. If the investor is a minor, is court approval necessary for the investment? That's a really good question. No, I don't think court approval is required. There's been a debate. Most people seem to think that a 17 and 18-year-old can invest. It really comes to a secondary question of to what degree could a 12-year-old be involved in decision-making. I think 12-year-olds too young. I think if somebody's over 16 or 17, arguably they could be involved in decision-making to some degree, at least policy development. So I'm going to say court approval is not required. If you want to try and get court approval, maybe interesting alternative. Dad gave son $1 million for EB-5, so son is an accredited investor or not? According to Jor, our authority, the answer is yes. Jor, this is a question for you, and it's coming from a player in the game. Is it true that the accredited investor requirement is only required in Reg D offerings? If a Reg S offering is made, there's no accredited investor concern, particularly relative to a, quote, kid that is being given money to be an EB-5 investor. Also, the father could be the accredited investor if necessary, and the kid, if a minor, could come in under EB-5. Any comment on that, Jor? You see that question? Maybe I've lost Jor. Sound? Jor is not on. Okay. I'm sorry, I'll have to keep that question for next time. Tech gentlemen, let's take that and email that question to Jor. I think I've lost Jor. I know he said he had to run. What is guest expenditure? You'll see that on the slide. That is the money that the guest spends in the hotel. So I fly to New York, I stay in a hotel, and I don't buy my food in the restaurant. I buy my food at the McDonald's next door. And it is my purchase of that food at McDonald's next door that contributes to the economy and could be factored into the job creation for that particular area. That in a nutshell. Or I go out and I buy, diamonds and stuff when I'm on vacation. But such expenditure by their very speculative nature, will there be any guess on not verifiable? Yeah, that's true. Such expenditure by their very speculative nature will be, it's not going to be precise. And that's what Aaron spoke about in the terms of putting in third-party verifications. Here's my friend Jan Peterson. We have lots of questions. Well, oh gosh, your questions are coming through. Jan is one of my dearest friends. What is another great webinar? Wow, well, thank you. Love these programs, would listen to Bernie anyway. Wow, I should pay you to say these things. CLE is way helpful. Yes, it is, and the price is right. Thank you. Can you send the presentation and recording link? Yes, all of these will be available. The presentation and the recording link will be available. What is the latest point in time to replace a bridge loan? Ouch. Can a project still receive EB-5 capital 1 year after the project has been completed? Hey, that's the big deal, okay? You have to have anticipated that the bridge loan would be replaced. The idea that, the hotel's already been built, the shopping center's already been built, and then you decide to go out and get EB-5 money? Come on, you're not making the jobs. Those jobs were already there. That's an afterthought. So you have to clearly outline right at the beginning that you plan to use bridge, mezzanine, as the players talk about mezz financing, and that you're going to get EB-5 financing to replace it. The government's position is pretty reasonable in my opinion. Where can we find a list of centers who have I-526 denials? No, you can't find those. Little joke in the industry, nobody's got a 526 denial. Everybody's got 100% approval rates. Nobody admits to these. How can we get a copy? I'm sending it to you guys. How complex and costly is it to do an EB-5 to raise $2 million for a tech company? Hey, tech companies are regarded as risky. The Chinese market is smart. The Chinese investor is very careful. They want collateral. If this business is going to fail, they want to know there's some dirt, land, property, something of value. So, tech is traditionally risky. Do you go at it your own, or are you required to go through a regional center? Look, the whole thing about regional centers, for those of you who are new to the program, is you get to count indirect jobs. If you're going to raise $2 million and you're going to hire 20 new U.S. workers, you don't need a regional center. What for? Who needs the headache? You want to raise $2 million? $1 million each, 10 investors each, scratch that, 10 jobs each. You got a very, very simple project. That's a direct. You don't need a regional center, don't need the headache. The only time you're doing a regional center is if you want to count indirect jobs based on, for example, construction costs or operational costs. Be very careful if you want to start counting tenant occupancy. Okay, I'll keep going. There's still lots of questions here. Am I sending? Yes, I'm sending. Is the Foreign Account Tax Compliance Act causing concerns for any potential investor immigrants? Foreign Account Tax Compliance. I think I'm probably misunderstanding your question, but is the fact that once you're a U.S. resident, you have to disclose all your foreign bank accounts, is creating a problem? I don't think it's hit the radar screen yet. This is the FATCA, F-A-T-C-A, the rules, IRS rules. Not an expert in this arena. All I can tell you is they don't want to open up bank accounts for Americans in Europe anymore because that information has to be disclosed. If you have a bank account abroad and you're a U.S. citizen or permanent resident, you need to disclose all those foreign bank accounts. Oh, I got some very good input from one of my friend immigration lawyers. There is a single petition approach to CISPA 203H3 age-out derivative in employment-based cases not affected by the Supreme Court case. Thank you, David. I appreciate the input. There's a whole bunch of lawyers on this webinar, many of them more knowledgeable than me. And there's one, David Froman, CISPA 203H3 age-out derivative. Hats off to you, sir. In your opinion, which model is better? Equity-based or loan model? Okay, the loan model is in vogue right now. The perception in China is that you got a better chance of getting your money back via the loan model. Equity model is very hard to sell. Remember, under the loan model, the idea is you get your money back in 5, 6, 7 years. Under the equity model, well, you don't get your money back until the equity or the business is sold. But if there is a plan to sell the business, then, well, yeah, it could work. By the way, thank you very much for sharing your knowledge. Thank you. And the sense of humor, yeah, it's not bad. Sometimes it works. Very informative and fun to attend. Tell your friends. Keep going. We're going to hit 700 on the next one. Does a broker-dealer need to, I'm going to shut off in about 3 minutes because we pretty much covered all the questions. Does a broker-dealer need to be FINRA registered if all of their broker-dealer functions are performed offshore? I don't know if I've still got any of, who do I still have online? No.
I'm here, Bernie.
Which one?
Hey,
Jor?
Bernie, it's Mike. No, it's Mike here.
Oh, Mike, thanks. You're not showing up then. This is your question. Does a broker-dealer need to be FINRA registered if all of their broker-dealer functions are performed offshore? So I only do stuff in China. Why do I have to register with FINRA?
Yeah, the problem isn't so much where the marketing is held. It's where the activity involving U.S. commerce. So if you only work offshore, then the answer would be no. But the issue is all the marketing is done offshore, but the bank transfers, the wire transfers, the emails, the actual investments, the securities document preparation and the issuance, and all of using the conveyance, and Jor would say this, I'm just substituting for what he would say, but he's often repeated this. If you use the instrumentalities of the United States to affect commerce or in the sale of a security, of a U.S. security, then the answer, and you would take a commission for doing that, then the answer is yes, you have to be registered.
Got it. Thank you, Michael, and thank you for staying to the end. I've gone over time. I normally try and cut these out a little bit earlier out of respect to your time. There's one question from an experienced immigration lawyer here. Chinese money meaning Chinese PRC sent to Hong Kong, Hong Kong to the US to avoid Chinese currency problem. Is there a source of fund problem? Answer, no. No. You fully disclose all of this. There may be a problem if you are breaking the law of China, but you know, we're talking about US here right now, and there's absolutely no problem from that point of view. This is what we call friends and family. Chinese nationals, 50,000 each annually, so they give it to 10 friends, and the 10 friends then send it out, or sometimes it goes through. I'm not talking about Chinese currency compliance. I don't give advice on Chinese law. You know, Chinese lawyer for that, but I can tell you that this is the way it's done, is generally the money is sent out through friends and family. Also, check out the new Bank of China program, where a lot of the transactions are being done where they actually get permission from the bank to ship the money out directly. So that's happening at the moment in a lot of cases. Folks, we are fully out of time today. I hope you've enjoyed this. I am thrilled that we got over 500 people registered for this program today. Thank you to my panelists, to Jor Law, to Aaron Goforth, and to Michael Gibson. This is Bernie Wolfsdorf signing off. Until next time, we really appreciate your participation today, and look forward to having you on the next program. And we have your email address, so we'll be contacting you, and certainly look forward to that. Thank you so much, everybody. Have a wonderful day. Have a wonderful summer, a wonderful life. And the program is good. It's moving forward, but be very careful of some of the pitfalls that my esteemed panelists have explained. Thank you and goodbye.